So, good afternoon, or good morning, or good evening, depending on where you are right now. I must say that I am very happy that Columbia Global Freedom of Expression was able to host this wonderful event with such extraordinary people. It's truly a privilege. Of course, this would not be possible without the support and collaboration of Article 19 and UNESCO. Article 19's advocacy work in favor of freedom of expression has proven to be essential in furthering and renewing our understanding of this right and the challenges it faces at a global scale. Without it, this would, this whole conversation would be fruitless. For its part, UNESCO's permanent commitment to human freedoms continue to be indispensable to fostering a better environment for freedom of expression, now more than ever, when strategic litigation against public participation has become so widespread. On the topic of SLAPPs, Article 19 has written the wonderful paper we are launching at this event. So thank you very, very much, Barbara, and all your team for this effort. This paper is part of the special collection of the case law on freedom of expression, a project that arose basically because we understood the value and potential of our database and the importance of systematizing the case analysis that we include in that database. Through our joint efforts, we hope to be able to provide a useful set of tools for judges, litigants, activists, journalists, and members of civil society in general by highlighting the emblematic decisions issued in key jurisdictions. I do believe in that regard that our database is quite like no other, with over 2,000 entries, case analysis, and 11 papers published, aim to be at the forefront of the study of legal trends to provide current information for contemporary challenges. Of course, Article 19's paper on SLAPPs fulfills and surpasses these expectations. Indeed, it's a truly extraordinary endeavor for which we are profoundly thankful. Similarly UNESCO has recently made a significant contribution to the topic of SLAPPs with the publication of the recent report on the misuse of the judicial system to attack freedom of expression, a wonderful analysis on how the law is being abused currently and globally to curtail expression. Without a doubt, the issue of SLAPPs has become one of the most relevant challenges to freedom of expression at the moment. Authoritarian regimes and illiberal governments, besides restoring to traditional violence to silence criticism, have made use of SLAPPs to stifle debate, especially in authoritarian states, as democratic ones. Furthermore, this phenomenon has also thrived in traditional robust democracies where the rule of law has been abused to suppress expression on matters of public interest. Due to its novel nature, in many instances, judges lack the proper conceptual toolbox to address these cases in their rightful dimension. Nonetheless, all the work undertaken by advocacy groups has been instrumental in advancing judges' comprehension of the severity of SLAPPs and their insidiousness. The recent decision of the Inter-American Court of Human Rights in the case of Palacio Urrutia versus Ecuador set a telling and optimistic precedent. In it, the court considered that the freedom of expression of a journalist who wrote an opinion piece that criticized then President of Ecuador, Rafael Correa, was breached because he was criminally convicted and sentenced to pay over $30 million in damages. There, the court held that SLAPPs are an abusive use of judicial mechanisms that deserve regulation and control by the states in order to protect the effective exercise of freedom of expression. There's still a lot of work to be done to protect freedom of expression, but I am certain that without the work from civil society and international organizations like Article 19 and UNESCO, the accomplishment in this field would be far fewer. Thanks again for your assistance today, and I leave you with Stephen Townley, who is Legal Director of the Trial Watch Initiative.
Thanks so much, Catalina. Hi, everyone. I'm Stephen Townley. I'm the Legal Director of Trial Watch at the Clooney Foundation for Justice. Very briefly, Trial Watch monitors criminal proceedings around the world against those who are vulnerable to abusive legal process and advocates for the rights of those unfairly prosecuted or convicted. We're also building a global justice index based on data we're gathering from courtrooms, which is then assessed by legal experts. So today, I have the privilege of moderating the conversation, which I hope will be extremely interesting on the basis of the Article 19 report, as well as UNESCO's report on the misuse of judicial systems to attack freedom of expression. I'm hoping we can have as interactive as possible a conversation. I'm going to briefly introduce our two panelists. Then I'm going to turn first to Mehdi to introduce his report, then to Barbara to introduce hers, and then hope we go straight into a conversation, questions and answer. I may ask a few questions as the moderator, but I would welcome questions both from the room and also from the chat. So if there are those who are following along online and you have a question, please just pop it into the chat and I'd be happy then to ask it of our panelists. So without further ado, I'd like to introduce Mehdi Benchela, who is the Senior Project Officer for the Section for Freedom of Expression and Safety of Journalists at UNESCO, where he coordinates the rule of law, policy, and freedom of expression team and has a wealth of experience on these issues. And Mehdi, I'm wondering if you could maybe for a few minutes speak briefly about the UNESCO report on the misuse of the judicial system to attack freedom of expression. And either during your introduction or later, I'm especially curious about some of the points that the report raises on the globalized and digital nature of expression now, and what this leads to when it comes to SLAPPs. But please, Mehdi, you have the floor.
Thank you, Stephen. So first, I think it's important to put this report and all this discussion today in the wider context of the attacks on freedom of expression worldwide. I think this is one aspect of this trend that unfortunately we notice at UNESCO. We published a report on World Trend report on freedom of expression, which really show the attacks on freedom of expression and in particular on press freedom, with 85% of the world population having experienced a downsize on the freedom of expression in the last 5 years. And this tendency to go back is what we have been noticing. Last year, also UNESCO has condemned the killing of journalists, of 86 journalists worldwide, which represents an increase of 50% compared to the previous years. So this is really, of course, the most the gravest attack on freedom of expression, to kill journalists, because not only you kill a man, you destroy the possibility for him to work as a journalist, as expressing and looking for information, but also you deprive the whole society of a reliable source of information. We also have noticed attacks on journalists during protests, during election, with between January 2019 and June 2022, 759 attacks against journalists in the context of 89 election. And also out of this data, we noticed that 42% of the attacks were committed by security forces. So it's just to put this report, because we can say in a way that it's a new trend. There's attack to silence journalists by using the judicial system, but there is the old threat. They're not going away. They are actually increasing, and so I think I just wanted to put a little bit of context. So regarding this report on the the misuse of judicial system to attack freedom of expression, there are some key trends that I would like to share in order to feed the conversation and on this very important issue. So first is that the gradual trend towards the decriminalization of defamation is unfortunately slowing down, and there is still 160 states which still have not decriminalized free speech. So that's and defamation. So that's really a first and important trend. The use of criminal defamation offenses to restrict online expression has increased, so worldwide, and several states have really harshened or reintroduced provision on libel, defamation, and insult by stating new laws intending to address cybersecurity, fake news, and hate speech. So we see new laws actually being used to, maybe we can talk about that, to curtail freedom of expression with specific provision, which, but also this is not only about the criminal defamation, the use of civil defamation with disproportionate condemnation that in effect actually limits and create a chilling effect among journalists. So that's also something that we can talk. There have been a rise in abusive practices such as forum shopping and the SLAPP that we have been starting to talk with Catalina, because actually I didn't thank Columbia University for their, because I should have started with that. Really, this is an incredible partnership. It's a little bracket, but really a pleasure to work with the team at Columbia, and we've done really incredible work on the database and other things. But anyway, it's just a misstep from me. To go back on the trend, there is still one aspect which is interesting, is the jurisprudence of an international court on human rights, which has reaffirmed that speech about public official is especially protected and must receive a proportional treatment under civil rights. So somehow the fact that the regional legal framework are taking this into account and are making landmark decision, I think that's an interesting aspect. I will end here, and I will let Barbara or you to speak. Thank you.
Great, thanks so much, Mehdi. And I think there's a lot of points there that we can follow up on. But first, I'd like to briefly give the floor to Barbara Bukovska, who is Article 19's Senior Director for Law and Policy, where she leads the development of Article 19 policies and provides legal oversight across the organization. And I wanted to give her a few minutes to introduce the Article 19 report, which is part of the special collection here at Columbia on how courts are responding to SLAPPs. And I think there are many points there that we can talk about. In particular, perhaps at some point, we can come to what courts are considering when they're taking these decisions that Mehdi referenced, including on questions of whether speech is in public interest. But why don't you go ahead and introduce the report? The floor is yours, Barbara.
Yeah, thank you. Thank you so much. And thank you for everyone being here, and also those who are watching us online. I saw some names, and it's quite clear that you decided to spend your evening watching us rather than Succession on Netflix. And well, it's not on Netflix, on something else. Anyhow, so I also want to thank Columbia for this partnership, especially Holly, who drove this project forward. It's been a pleasure, and also to my colleagues who contributed to it, especially Paulina Gutierrez, who I also see she's watching online. So about this report, it's now online, so you can read it, and I will only summarize it for you because you can read it if you like literature or even if you don't. But it's attempt to try to summarize some trends from positive jurisprudence as per the collection of cases on Colombia freedom of expression databases that Catalina already mentioned, that summarizes also some decisions in cases that can be characterized as SLAPPs. And with particular focus actually on the jurisdictions that do not have specific protection against SLAPPs, because some countries, US, Canada, Australia already adopted SLAPP, anti-SLAPP protection. So this is in the jurisdictions where such protection doesn't exist. And we look at some of those cases, and this is not by any means comprehensive because it's like 20 cases. But what we noticed is that some courts, especially those from regional human rights systems, are recognizing the problem of SLAPPs to freedom of expression. And they're also specifically referring to protection against SLAPPs or the need to adopt protection against SLAPPs in their own legislation. So they are saying that this case ended up with us, but it's not the role of the courts to provide procedural measures that will prevent these cases ending up with us. So legislation needs to be amended, and legislation needs to be amended under which these cases are being brought, but also procedurally. So that's quite important. And then they are also using some provisions which are already available in the legal framework, especially abuse of rights or abuse of protest, and dismissing these SLAPP cases under these provisions. They are doing it on different bases, so you can see in the report, but that's kind of innovative approach of the courts to kind of recognize the problem and then use this sort of protection already available there. So this might sound as what Catalina in her opening called positive picture or cause for optimism. But here is the spoiler alert to the whole thing. That is that in conclusions, we actually highlight that these decisions or these protections actually come from the highest courts in the jurisdictions, Supreme Courts, constitutional courts, or even regional courts, such as European Court of Human Rights or the Inter-American Court of Human Rights as well. And that's actually what is the problem with SLAPPs, that their aim is to exhaust the applicants or exhaust the defendants and drag them through this years-long legal process in which they need to spend time, effort, and legal means. And if the protection is only coming from the highest courts, which took 10 years to litigate, that's kind of defeat the whole point of protection. So that number one. And number two is that we actually don't know what's the influence of these high-level court decisions on the lower courts, whether these courts are following the guidelines from this highest level of protection and applying them in subsequent cases. So really the report, although it's showing a positive picture, a positive protection, is really a call for reform, and we want to use it as an advocacy tool, to use it as an argument for legal reform and for adoption of a dedicated anti-SLAPP protection in domestic, in national laws. So that's the summary, and hope you read the report, and I'm looking forward to discussing the details of it.
Great. Thanks so much, Barbara. And I think it was really helpful the way you squared the circle in some sense between the backsliding that Mehdi described and the reasons for optimism that Catalina had identified. And I think that's a very interesting feature of the report, which is sort of, how do those two relate? What is the problem? What is the limited optimism, and how do we build on those grains of optimism? I wonder if maybe one place to start is in terms of framing that problem, the backsliding, or however you want to describe it, Mehdi, the widening set of tools that are being used to suppress freedom of expression. So I wondered if I could ask maybe each of you to say a couple of words about what laws or kinds of laws you see most frequently being used or misused to suppress freedom of expression. Maybe I could start with you. Going down a little deeper from the big picture you started at, what are the trends you see in sort of how the law is being used to suppress freedom of expression?
First, the use of the criminal proceeding against journalists and media. Of course, it's a very, very dangerous Damocles sword, I would say, above the media and journalists to potentially have a criminal condemnation. So this creates a huge chilling effect. And this, unfortunately, it's still really what is the widening reality of the legal system around the world. Even in some countries, the criminal law are not being used. It's still there as a threat. It can always be enacted, and you have cases. It's not in the report, but you have cases in some countries where the media have a few proceeding criminal against, and then they are going to be arrested, and then the president has somehow to pardon or has to do, because this is going to put a stain on the country, or you have a. So these are, the threat is always there, and if you're not using it, it's better to repel it completely. So the fact that it's still there, even in countries which are not using it, it's the case in some European countries, for example, remains a threat. And unfortunately, we're losing steam in terms of advocacy, in terms of convincing states to repel this law, which maintain this very harsh, very harsh potential sanction against journalists under criminal law. And normally, according to the international standards, normally there is really a tool which has been developed by the international system, by the regional court, by the Human Rights Committee, to limit freedom of expression when the case, a rare case, exception where you limit the freedom of expression, because freedom of expression is also, as we know, it's not an absolute right. Freedom of opinion is an absolute right, not freedom of expression, and it can be limited, but this must obey to some criteria, and the three-part test, which state that the limit should be legitimate, legal, and necessary and proportional. This is a very important test that should be used when it comes to limiting freedom of expression, when there is it infringes some other rights, like the right and reputation of others. So that these are important things that should be recalled, and this kind of tool to be put in the legislation at national level, because as much as possible, and used by the judge. I think that's few things that I could say about this. But the other thing is that it's not only about the issue of the criminal law, is that we notice also the use of civil proceeding against journalists, or procedures, which impose also extremely important damage potentially to the journalist for what may be an excess of freedom of expression. So if you condemn a newspaper to $4 million of fine, you destroy the newspaper. So this is, even if it's a civil condemnation, it remains disproportional and not necessary for the aim. And there is other, and that's what the United Nations or the society is proposing, is there is other remedy, like correction or apologize, which are other ways to remedy to problems related to excess of freedom of expression in a way. So that's a few words.
Great. Thanks, Mehdi. I don't know, Barbara, maybe you can come in from your look at the cases. And in addition, I'll tack an extra piece to the question on for you to make it more challenging, which is in addition to sort of what you see as the problem, I'm wondering if there are pieces of the problem that you think have yet to be sort of fully grappled, even at the international, regional places where you have this good jurisprudence. Because I wonder, I mean, Mehdi mentioned, for instance, cyber laws and other laws. Are those also, do we see grains of optimism there as well, if those are part of the problem, or is it only part of the problem that's yet been addressed? But over to you as to what the problem looks like.
And he has a really hard questions, which I only have myself to blame, because original idea was just to present the report, and I was like, well, that's going to be so boring. So now I will be in trouble. But actually, when I was listening to Mehdi, I think we need to conceptualize the problem slightly differently. Because I think we tend to understand SLAPPs as any law that is applied against journalists. And criminal law, like crazy defamation law, broad laws, obscenity, and so on. But, to me, when I was looking at SLAPPs, and it also comes from like Article 19 work, when we always said the criminalization of defamation of certain laws needs to be accompanied by the proper reform of these laws and make sure that it's in the civil law. But then the civil law is being abused. So how I have seen SLAPPs has been always that you need to have you have to have legislation which fully complies with international freedom of expression standard. So not vague defamation law, not vague obscenity law, not vague public order laws. But even the good law can be abused, and that's when SLAPPs come in, right? So how do you prevent the good law to be applied against journalists and exhaust them through this means? So that's how I always understood SLAPPs. That's not how popularly we understand, and we now see everything when every time journalist is sued, it's a SLAPP. So that's slightly different, and we need to separate these problems in a different categories. But coming to that, and actually it's quite important, if we don't, we are gonna see something which I was quite surprised myself, that in some countries, when there is a criminal law which is hanging over as a threat against journalists, it exists, but it's never applied. And we say this law creates a chilling effect, and we want it decriminalized, and then we want it to replace by civil law. But then journalists are seeing that when civil law comes to place, they will face these high damages. So they say keep the criminal defamation in place, because at least it's not going to be applied, because if it's then, we are much faster. So, and this is not a hypothetical situation. This is exactly what is happening now in Italy, when the journalists are saying, please don't criminalize, because we are going to go through these trials. It's going to take a long time, but we don't really care, because at the end, we will not be sentenced to prison anyhow. So that's something which we need to consider. And that's why I think that this conceptualization of SLAPPs, it's important, because that good law, good civil defamation or other reform needs to be accompanied by these procedural guarantees to prevent the abuse. I don't know whether it makes sense for like non-lawyers. Sounds like super legalistic, but we need the procedural measures that judges can apply and drop these cases from the very beginning. So the court will actually not even decide on substantive legal basis. These cases will be dismissed very quickly in a timely manner, and then the costs which you accrued in the process before will be quite low. So you don't need to wait for 10 years, and you will get them reimbursed quite quickly. So that's what I think conceptually. This is what we need to consider. And the enabling environment around SLAPPs needs to be positive. We can't have, you can have the best protection against SLAPPs. If you have a criminal defamation, it's not gonna help you. Or if you are gonna have, some national security law, which can be applied to you anytime. So this is the kind of legalistic distinction, but I think it's important.
I think that's super helpful. And maybe if I'm hearing you, I sort of see maybe three topics for us to discuss. One is at the level of legislation, reforming the bad laws, putting in place the good laws. There are some laws we know on their face are problematic, criminal defamation. But then your second point is, what about the misuse of good laws, quote unquote? Where it's instrumentalized for the purpose of a SLAPP. And then the third point that I think you raised is sort of what is the impact that we see? Because even laws that we think are not as bad, maybe they have a very serious impact. Your example of devastating damages being awarded. So I don't know, maybe we can go through these multiple buckets. I don't know, Mehdi, you looked like you wanted to come in.
I want to complement, or if I can, some reflection about what Barbara just said. Yeah, there's some countries who, for example, journalists or media association prefer to a system with criminal law, because the statute of limitation, for example, is very short. After 3 months, it's finished. So for them, they know that if there is no procedure in the 3 months, they are off the hook. Of course, the problem is that in these 3 months, they can trigger something very dangerous. But they bet on the fact that it's not going to be, and the judge will dismiss it very quickly. And so I completely agree. The idea is not to replace criminal law by bad civil law, which are impose non-necessary or proportional damage against journalists, because then it's you are exactly displacing the problem, and then you're creating this potential for SLAPP for endless procedures against journalists, which are extremely costly and which are draining the energy of the journalists, the media. And actually, it's a strategy in some countries. It's a clear strategy, and the media owner will tell you, I'm spending my weeks traveling from one court to another and spending more time with my lawyer than running my newspaper. That's really clear, and it's a strategy to exhaust them. Just don't have the time. Just don't have to keep working. That's and then while you do this, you say, well, I'm respecting the law. You can. So we have to actually, really take into account that if taking out criminal law, changing by civil law, but really with applying the international standards of legality, legitimacy, and proportionality and necessity. I think it's crucial. But I think for this also we need to raise awareness of the judicial actors. That's not at the level of legal, but really judicial actor, lawyers. Lawyers, but also really judges. UNESCO actually has this judge initiative to train judges, prosecutor, and lawyers around the world on freedom of expression, legitimate limits, etc. And I remember having a testimony from judge from Africa telling, "Oh, I didn't know about this story of SLAPP, because in some cases very new, and they don't realize that somehow then they realize that their work, the court's work, is being used against, but if you're not aware, you might not realize that there is a strategy there. And you are, because we briefly talked about that. Access to justice is also a right, an essential right. So the judge is not inclined very quickly to dismiss a procedure like this, because he has to give access to justice. It's also a fundamental right. And the right and reputation also of others is also an essential, fundamental right. So how do you balance that? And then I'm stopping there, but we can keep discussion on this.
But I think you were alluding to like what kind of other laws are, because it's not just defamation, right? So like increasingly what we see is what we call like administrative procedures, when, the newspaper or a media outlet will get like frequent controls from, let's say, tax authorities or like social benefits or whatever is this, employment kind of laws. Or increasingly in Europe, right to be forgotten is when a lot of, it's especially relevant, is a lot of media outlet digitalize their collections. So now people are going after them, like you were some oligarch years before, somebody wrote about you. So now you are going after them and asking them to delete everything. So right to be forgotten is quite important. And it's not hypothetical again, like Italy might sound like I'm just obsessed about them, but there was a newspaper which had to close because of the right to be forgotten claims. And interestingly, I even saw the cases, which was like super clever, of using psychiatric sort of like, how we call it, so asking to put someone to psychiatric hospital because or considered like crazy and making all these allegations about like politicians, which is very difficult to actually in some countries to go after this kind of procedures. So I thought it was kind of clever thing from an oligarch to use. So it's not just defamation, it's a myriad of laws that we need to be aware of.
Yeah, I think this is really helpful in crystallizing just how big the toolkit can be, and how much if you push down on one piece of the hydraulic, maybe something pops up over here, and then you've got your hands in all of the spouts. I do have some questions I want to come back to on that, but I saw a good question in the chat that I wanted to bring to the panel's attention, which is whether you see differences at the regional level in the particular tactics that are being used. Are both at the macro level of whether there are particular regions that are where SLAPPs are expanding at a more dramatic rate. But I'll add on, are there different tactics that countries and individuals in these regions are using, where in one place you see more criminal defamation, and the other, as you say, maybe in Europe there's more right to be forgotten or other provisions. So I don't know who would like to tackle that first, but the question is really about sort of regional variation in the tactics recognizing there is this big toolkit. Maybe.
It's a tough question. Do you want to start with?
Okay, well, I'm
Barbara.
Kidding.
happy
I'm
to
kidding.
start.
I don't.
Do you
No,
want to say?
I don't have specific data on different use of SLAPP according to different region and the different tactic. Personally, in the report, we have about the criminal laws there is some progress, more progress that have been done in Latin America, for example, with I think 18 laws which have been repealed about criminal defamation, 14 fully and 4 partially. So there is a progress, I think. I mean, according to the report on these things about criminal defamation, not on SLAPP, and specifically in Latin America, in Central Europe. Mainly as a region where there is more progress, I would say, on this issue of accountability.
So again, this is not in the Columbia report. This is from general Article 19 work, and we also published a big report about SLAPPs in Europe. So I would say in Europe, the problem is on increase, and that's why also the European Union is actually addressing this in a dedicated directive, although that deals with transnational issues within the EU market. But I would say yes, in Europe, this kind of cases are increasing, and we haven't looked, but it's would be really interesting to see how the criminalization of defamation or removal of certain criminal laws then leads these people who are bringing SLAPP cases to rely on civil defamation laws or civil laws. And it's also kind of important to know that there is also, for a lack of a better word, a SLAPP legal industry. So there would be some law firms that would be specializing in bringing these cases. And it's also in the jurisdictions where are quite known for previously libel tourism or bringing cases there when it's very expensive to bring cases and then very expensive to defend the cases. So if you are a media outlet being sued, you are from Vietnam, and then you are being sued in the UK, that's really a SLAPP case because they want you to hire a lawyer, or they know you won't be able to hire a lawyer in the UK, and you will spend a lot of money to defend yourself in the court in a country where you actually don't even are based off.
That's super interesting. And I should say, just to folks in the room, if anyone has a question, just signal, and I'm happy to open this up, or put the people behind make a sound, and I'll turn around and we'll invite you into the conversation, because I really hope this can be as dynamic and interactive as possible. I wanted to pick up on one thread that I've now heard a little bit, which is the interplay between the criminal and the civil side. I mean, we've been talking a little bit about, well, maybe if you do away with criminal defamation, is there then more recourse civil defamation? And I'm curious sort of what you see as the relationship between civil and criminal SLAPPs, and also whether there are any things that can be read over one from the other in the vein of the procedural mechanisms, Barbara, that you mentioned at the outset. Are there any lessons? Maybe you mentioned maybe you have a 3-month limitation period in the criminal law, and you have a very long limitation period in the civil law. So maybe if either of you could offer some thoughts on what's the relationship between the two, both either is there anything positive one can pull from one to the other, or negatively, are they mutually reinforcing?
Well, they're mutually reinforcing, but I would say, and again, we didn't really study this in a detail, and when we wrote our report from EU, it was very much focused on civil litigation, civil cases, and criminal in the background. I would say that the civil ones are, to be honest, much more impactful, because that's where you often don't even have a right to free legal aid. Right. So in many cases, when you have a criminal law, if there is a punishment leading to prison, in some countries you have a right to legal, or the state gives you legal representations, even if you have to pay for it subsequently. So there is intersections between them, but our focus has been always to look at the criminal SLAPPs as a background, and sort of bad enabling, there is no enabling environment for freedom of expression, and focus on the civil ones. But understanding that the civil ones will be problematic eventually.
Yeah, I don't have much to add on this. I think it's you have people, powerful interest, either from national authorities or from private sector that don't want scrutiny, don't want accountability, and they will. And if they're faced by the work of journalists exposing some malpractice or wrongdoing or corruption, they will see what do they have in their as available in the legal system, and they have very well paid lawyers which are really good at finding what are the tools, what are the weapons in a way that they can be used, or how they can exploit the system, the judicial system, to get to the aim, which is to silence the journalists, to scare the other ones, to keep because of course you send a message, and so some maybe the biggest media in the country has a resource to face that, and will say, okay, I am ready to take the fire for this incredible investigation, etc. But many small media which already are struggling financially, they are just going to back off. They're just not even going to go there because it's too risky for them. So we are already facing in a situation where they are in a difficult financial situation. We know the journalists, so this will support their objective of this powerful interest to silence or to scare other, and so then they will use, okay, if there is a criminal defamation law, we'll use that. If there is a civil, we'll just exhaust with endless procedures and other and new case, etc., to exhaust the journalists in France, and they will use what they have. And so now, what is important is first to be well aware of that, and I think these reports are useful. That the civil society, the judicial actor are more aware of this. That actually they are being exploited in a way, and then also to have a strategy to face that. So I think training judges and prosecutors that they can be used against, and that I think is important, but also to give possibility to the media to have legal support in order that they're not alone to do this, that there is legal support, free pro bono to face this highly paid lawyers which are defending this powerful interest. I think it's important. Also, I think maybe Bara, you can speak more about that, because I think you're part of the expert group, but the Council of Europe work on SLAPP, on directive. I think it's an interesting thing because it established very clear criteria that will that I think is important, to have very precise criteria for the judge when there is not a law, but for the judge to say, okay, clearly I'm in the face of this. I'm being this is the 10th procedure this person is using. He has, etc., etc. They're very clear criteria, and I think maybe you can speak more.
But before that, actually there is one trend which I haven't mentioned, which is quite interesting, is that and it's related to the use of journalists of social media. Yes, obviously, like journalists, they publish articles on their media outlet or are author, but their lives just doesn't evolve only around their employment. They also have like private accounts, and this was kind of interesting thing which we noticed in few cases when a powerful individual, like oligarch or somebody who is paying a political party, will actually go after journalists not for what they published, but for either what they said on social media, or what they say in quote unquote non-journalistic activity. So an example of that is Carol Cadwallader. She's a British journalist who was very instrumental in uncovering sort of like financial interest behind campaign for Brexit. So she wrote about it, numerous articles about it for The Guardian, and then she gave a TED talk where she spoke actually about exactly the same thing in that, but the person who she was writing about sued her for that TED talk, and that was not covered by the insurance which she had under her if this was for the media, And similar case was also in Thailand. A journalist who was covering something for the television, then wrote about it on her, I think, Instagram or TikTok. So and a couple of other cases like that. So that's again like something which insurance would not cover, and the journalists should be really like careful about. And silence is like journalists, unless you are doing everything from your position of employment, you are totally silenced in your quote unquote private life.
I think that's super interesting, and maybe I can try to draw these two comments together in the sense that I was struck, maybe your point about helping judges to see when they're being exploited, and this question of the criteria, giving them some guidance so they can discern when they're being exploited for these purposes. And then Barbara, to your point of sort of the sophisticated tactics that are being used where they try to get around whatever defenses are there, again, because their purpose is this silencing, not some vindication of rights. And so I'd be curious, and I know this is addressed in the report, how are courts trying to decide what's a SLAPP? And what are the trends that you see at these high court levels? Because there are these two strands that I sort of hear a little bit. One is, why is this case coming? What's your motive for bringing it? And the other is, what are the objective criteria? Is this speech on a matter of public interest? Who are we talking about? So I'd be curious for your thoughts, Barbara, maybe from the report, which I know addressed this a bit.
Yes, so we look, this was not addressed in the report or in the cases which we look in the context of SLAPPs, anti-SLAPP provision, because in those jurisdictions, there was no anti-SLAPP provisions. So the courts applied those rules under the abuse of process, which is, I understand, very specific for each country because they follow their national guidelines or like previous jurisprudence or established system. But you already answered partially that question. They look at the motivation of the plaintiff and whether the plaintiff filed similar cases in the past. So how many is that similar to many cases which brings against this particular outlet or other outlets? And then also what is called for those lawyers who are here, whether it's like single publication rule or multiple publication rule. So if in some countries you don't have, and this used to be kind of normal during pre-internet time, but now every single time you open a document online, it might be when the statute of limitation might look like. So it's called like single publication rule. So if somebody can bring cases indefinitely because you don't have just single publication from the moment you publish. So that was quite important. And then they look whether the defendant is targeted for exercising certain public interest work. So it's a journalist, activist. Is this a person who is just criticizing something in a genuine good faith? There was a case, I think it was from South Africa, when a teacher criticized some electricity company for exuberant prices they had to pay, and then the electricity company went after her, and she was like 72. So the courts are looking at that. It's not really codified. It's not like a set of criteria which the judge needs to go through, like a list. And that might be something useful to develop in recommendations or even from upper courts or regional human rights bodies.
Yeah, maybe I'd be curious from your perspective of having engaged judicial sector actors. What do you think would help? What in terms of socializing the concept that they need to be on the lookout for some set of characteristics?
First, I mean, UNESCO is works a lot with judicial actors and but also with law enforcement officers, and for many years now, since 2013, and Latin America first, and Africa, and now it's a global project. But first of all, it's interesting to realize that we have in all these trainings we do, we have a huge distrust. Judicial actors, the judges, and the prosecutor they have a lot to say about journalists, which is not always positive. And we shouldn't deny that there is good journalism, bad journalism, like there is, good education, good judge, bad judge. So it's not about saying that everything is perfect, but it's about how do you correct the things, and the control of proportionality and necessity. That's it's a key. And so when we start to engage with them, and we're not defending everything which is being said, but of course, because there is some abuse, but these abuse, they shouldn't how do you say, the correction shouldn't destroy the right to freedom of expression, because it has such consequences for the whole society. And for the big part of the work is just already to sensitize and to give a perspective of why freedom of expression is such an important right, an essential right in itself, and as an enabling of all the human rights, including political rights. And this is actually the theme of the World Press Freedom Day this year. Without freedom of expression, there is no progress. There is there's very little possibility for human beings to share experience. So just to give already this and create to open their mind about that is already a big part of the work, I have to say. And then very concretely about really sharing the international standards. Because although all the states have ratified the ICCPR, the International Convention on Civil and Political Rights, the Article 19 about freedom of expression, very few know really the detail and how it can apply, how they can use it. And so that, I think, it's a big part of the work. And also to say that some speech are not protected. There is unprotected speech in Article 20 about propaganda for war, incitement to hatred, to violence, hostility based on religion, on race, etc. So these are also things that to really to cover these things, and I think it's very important in order that then when they have cases related to journalists and freedom of expression, they approach it in a very different way, completely, and they say, oh, next time I'll have a case, I'll look at it with a different angle. But I have to say that with judge, prosecutor, or law enforcement, it doesn't start very well when we start to engage about this issue, because the distrust is real.
I'm just going to look around and make sure. I see. Okay, we've started. Yes, sir.
Okay, my name is Mogens Bjerregaard, representing here the UNESCO National Commission in Denmark. I have two questions. One, when you make those trainings, the judges, lawyers, and etc., do you include also journalists when you make the trainings to have the confrontation, to have the discussions? I'm a bit curious about that, because sometimes I think that when you make all those trainings, it could be helpful to have the other part on board. And for you, Barbara, I would like to know more about the EU directive, because you have both the directive and the recommendation. What are your take on that? Will that recommendation would that be helpful? Because the directive itself is only cross-border. Only when you have cross-border SLAPP cases, and it's only a few of the cases that are cross-border, maybe 5-10%. The rest, they are internal in the countries, and here you need the recommendations. So what are your take on that? Would the recommendations be helpful?
Why don't we go ahead, please, Libby?
Yeah, so that's a very good question. So we tried everything in order to find something that works. So we're talking about very different actors, actually. First of all, when you engage and you have capacity building activities with judges, I can tell you cannot even mix them with prosecutors in most of the cases. So we're a long way from journalists having in the room, So we do bring at one point in some slot the head of the Association of Journalists or union to have an exchange, but we don't have them for the whole training, because it doesn't work. Otherwise we won't have an open discussion with them. They're very, very how to say, aware, and they are, how do you say, they're very they're really jealous of their independence, and they don't open except then when they are between themselves and the UN. It's fine, but to have journalists, it's for the whole training, it doesn't really work with judges. With prosecutor, we had a lot of exchange. We brought a lot of journalists especially, for example, we did a global training in Syracuse in Italy with prosecutors from 12 different countries from all over the world. And we had a few journalists coming, sharing their experience, but it's not any journalists. They come with the carabinieri. They come because they are under protection, because they are under threats on their life for 7 years. So they really see that these journalists are actually fighting the crime and living under the protection. They are really bringing essential information to the public, and so these we create a link, and so that's really. And with law enforcement officers, not really the question, but I will say then it's different. We really have them. We have the journalists and police officer for at least half of the training together sometime, because it works much better. It's we can do training together actually, because they are seeing that they are always in the same demonstration and crime scene.
Exactly.
They are always, but judge doesn't interact with a journalist on daily basis. But law enforcement officers, they do. So that's why we mix them at least for a part, and it works pretty well. That's it.
Great. Barbara, do you want to take
Yes,
the EU directive?
so EU directive. So for those who are not familiar with the European system, so it's a EU directive, European Commission, which is a part of the European Union, which is not a human rights system. It's a system of economic cooperation, has been kind of lobbied heavily by civil society to introduce protection against SLAPPs in the EU. And there is this directive, which was at the beginning super ambitious, and I was in the expert group which was kind of helping the Commission to develop the directive. I don't know whether somebody from European Commission is listening to this, but I mean, I'm not defaming them, but there was the process which was sort of problematic from the start, because European Commission has only very limited sort of jurisdiction or limited realm on which it can rule. So there was even a question whether what they were trying to achieve would be accepted by the member states. And it's a directive, so it's not legislation. So member states have to agree with it. And then also they need to transpose it in their national jurisdiction. So from the beginning, we were kind of skeptical, and we were saying, like, what's the point of including the criminalization of defamation in this instrument, because Hungary, Poland, and so on, they will object against it, and this will never happen. But anyhow, so the first draft was extremely ambitious. It was like beautiful, but it was like non-starter, and it's kind of going that direction, because the version which we have now, which is actually compromise proposal, which came from the Swedish presidency, it's quite disappointing, and doesn't even have all the things which could have been there if the states would not torpedo it later. But even with all of this kind of pessimism in mind, what I think was quite useful from this process was actually the process itself, because we had a very good sort of system for developing this, and that was when there were independent experts from human rights organizations, from journalists, from bar association, from judges, working together and actually informing the Commission what are the problems at the national level. So if the papers from that process are published, it will be really useful in the domestic advocacy for improving the domestic protection. And also, in some countries, civil society and journalists are actually using this momentum with uncertain result of this directive to push for domestic reforms. So it's kind of nice case study of the useful process, which should be actually replicated by the human rights regional institutions. So, for example, if Pedro Vaca wants to replicate the process of the Inter-American system, this is the process to do. And you need to really be, and that also goes to your questions, which you give to Mehdi, whether you bring judges together with journalists. So this was the process. So you had a judge from like Luxembourg or judge from Italy, and then you will have someone from the Bar Association, you will have journalists, you will have even people who are working on like insurance, and to analyze the problem in its complexity, and then jointly propose the reform and understand each other, because it was even interesting for me to learn from all those judges, like what are they facing in the problems. And some of them are like in Belgium, like prosecutorial judges. So I find, although the result might seem quite hopeless at the moment. And the last version of this directive is, not something I would want to sign under, but it was still a useful process.
That's super interesting, Barbara, and hopefully we can come back on some of that, but there was a question back here at least, yes.
Yeah, I have a question. So, I was thinking about public servants and harassment in current cases in which they are being the subject of the what happens then? I mean, is there or like is it possible to start like a system of incentives or sanctions in which public servants can avoid using this kind of mechanisms to silence the press? It would be useful, it wouldn't be useful. And what about the right to reparation in cases, particularly where public servants are the ones that are harassing?
I'll throw it open. Maybe I can ask a clarifying question for the panel, which is, you mean in their official capacity, public
Yeah.
servants, or
No,
official?
their
official capacity.
The exercise of the roles as public servants.
Okay, who'd like to
So
take
the
that
only
one
thing,
first?
well, the few thing I can say that according to international standards and the regional jurisprudence, like in Latin America with the Anti-American Court of Justice on human rights, normally the right to reputation, which is being used basically by public servants to attack journalists which are covering their work or their whatever. It's not the same for a public figure or, for example, a prosecutor or a public servant and my grandmother. It's different. So normally they don't have the same rights to a protection in a way to their to reputation because they are public figure. Because they're like a politician or like a public figure, he has to accept that he basically needs to have a thicker skin, and so normally the jurisprudence, the consistent jurisprudence of regional courts, the African court also on human and people's rights is that public figure, for example, the case of prosecutors is a famous one, and don't enjoy the same level of protection, I would say, that a normal person, a normal citizen, which would be suffer defamation from a journalist, then the judge might be much more harsh because this person is not a public figure, it's been defamed in the media, on social media, etc. So that's a few things I could say about it.
Yeah, and also as if you are developing guidelines for the judges, what kind of cases they should be subject to a dismissal, the nature of the applicant, and if it's a public figure, automatically should elevate it to this expedited procedure. But also something, quite important, which we haven't addressed, is that there should be also a system where these cases against the media, particularly, would not end up in the court to begin with.
Mhm.
So the issue such as, or put more emphasis on self-regulatory systems, where you will have to go first to, if the journalist or media outlet is a part of the self-regulatory system, you will have to go there as the first point, and only after be able to bring the case, or what I call it, alternative systems of resolution. So that exists in some countries like UK, which used to be this like high level liable tourism kind of country. Now on this new system of royal charter, there is also system of the arbitration, where you have a low cost resolution of disputes before you can bring the case to the judge to begin with. And then only then you would have this expedited procedure for the judge to dismiss them early.
And I want to follow up on that, but maybe I can actually pick up on a last piece of the question that was asked and broaden the lens, and then I'll come to you.
But it's the same question.
Okay, go ahead.
Is how can we make like this a model of anti-SLAPP law, in which we can be persuasive or dissuasive of using these kind of measures from public servants or even from public figures, because I think they don't have any barrier to do so. They feel strong to do so. And even more when we have in countries from Latin America or Africa or Asia, this lack of independence in the judiciary branch, it's like we are talking about, guidelines and procedural rules of that kind of that sort of measures or warranties, that institutional warranties that liberal democracies have. But what happens with hybrid models or authoritarian models, and how can we go in terms of reparation for the victims of SLAPPs to be persuasive, so they cannot abuse of this kind of
I think that's great. That's basically where I wanted to go, which is, how do you dissuade? How do you, what is the system that doesn't even need the judge to say we're going to get rid of this because it doesn't get to the judge? Yeah.
Okay, so Paul, to your question. So obviously, I think this will not really work in the countries where there is no independent judiciary. So that needs to go back to what we were saying at the beginning, that you need to have this enabling environment for freedom of expression, you have good laws, but you also need to have independent judiciary, the judges who are not controlled by the government or this powerful figures. But then the ideal situation looks like that when the case ends up in front of the judge, there's a set of criteria under which they need to dismiss them quickly, right? So look at the nature of the plaintiff. Public figure, it's already first point to dismiss the case, but also to give the damages already for this quote unquote pre-trial stage of the process. Because if you are a journalist, you get sued, you already need to hire a lawyer and you already incur costs. So that as a part of SLAPPs, you will get reimbursed within this early dismissal of cases, and you would get even damages for that in some ideal situations. So that's the system. I don't know whether it will work in Mexico because judges and some of these public figures who are suing, including Article 19. I mean, it's not going to work there, but that's under ideal situation. So yeah.
No, this was the reimbursement, how the indemnization,
and so on. Yeah.
Not to the victims of SLAPPs.
To your question, what is the highest level of you should get, or like what's the biggest deterrent or the biggest dissuasion? So I think that this fines or damages or repayment of costs only work to a certain extent, because if you are a rich person, that's what you want to do. You have enough money to go after them and you don't care how much money you spend, and you don't even care if you need to reimburse their damages later on, or reimburse their costs later on. That's pittance for you, right? As compared to media. So there needs to be also additional sort of guarantees or additional mechanisms. And something which we are looking at in the UK is that what I mentioned at the beginning is this SLAPP industry. So you will have certain law firms who you will always go to, and then they are harassing journalists on behalf of their clients. And they would send you these harassing letters and stop, cease and desist. And some of them, they actually they lie about what they write in those letters. So it's not that they are genuinely representing their clients and defending their rights. I have seen many of those letters, and this is never going to stand in the court of law, right? But when you are a journalist and you see this, you get scared immediately, either or if you are a blogger or if you are a protester. So what we want to do also is to go through professional standards bodies after this kind of law firms, and to increase the internal, I don't know how you call it. So basically, when you can complain about a lawyer to the bar association or to ethical body for unethical behavior towards the clients. So I think that this is quite important. And if those law firms, and this is not to say everybody has a right to defense, right? So everybody can be defended. It's not that you are saying to the lawyers, don't represent SLAPPs, but don't engage in unethical and harassing kind of activities after the lawyers. And that's actually quite important, because if this SLAPP industry, it's a handful of law firms, it's not just everyone. And even now some of them have branches in other countries. And I have just seen some from from Czech Republic. Somebody sent me this letter, and it's a British firm which has a section in the country, and you immediately recognize them, right? So also have the whole toolbox of measures and remedies which people can use to stop this. But in Mexico,
Oh, I know, it's so many countries.
I lived in hope.
Yeah.
Mandy, did you want to come in on this, or there's a question in the back? Yeah. Go ahead, please.
Thank you so much. I mean, I think actually my question will continue discussion of what can be done in countries that do not have rule of law system and everything. And I wanted to continue on the distrust on SLAPP laws, but maybe on a more international level. So basically, I'm talking about this because I have an example in mind. I worked with the special rapporteur on Belarus, and I unfortunately evidenced the crackdown on media and on the protesters during the 2020-2021. And what happened was that the attacks on media were coming from all of the angles. Their taxes, if someone had a business, on their businesses, on their families, and basically the judicial in Belarus is frozen. They do not have a rule of law system that would make them independent. So it was basically impossible to approach them and negotiate what can be done with media and media lawyers there. But we also saw a great hesitancy on the international level, in like international NGOs, for example, or other international actors that were thinking about helping these media outlets because they didn't understand if, for example, if a media outlet was persecuted for taxes, was it a SLAPP or was it not a SLAPP? So they didn't want to intervene too much. And then it was too late because it happened very fast once it all started going. So my question was, can SLAPP guidelines that you've been talking about or any other mechanism that you may envision be used for maybe emergency legal intervention or refugee support on an international level? Because I did sense that also international players did not understand if it's a SLAPP or if it's still something that they should not intervene in. Yeah, thank you.
What I can say is that obviously there is and it's a very important point, the issue of being more aware. I think a lot of it gets more pregnant. We start to really more understand that there is the strategy, and then we can imagine some counter strategy with various elements on the use of criminal defamation or civil defamation as a way to silence journalists. But what you're mentioning is something that we're actually observing, and I think it's something that actually I think we should work on, is the use of tax laws, tax infringements, more and more in many countries to silence the media, because you don't know. If you're not an expert or anything, you say, okay, maybe it's true. But we have seen in the case, for example, of Maria Ressa, how it has been extensively used to prevent her from leaving the Philippines, from harassing her judicially, has been for years. That's really a clear case. But there are in other countries, in Latin America, and in many other countries, you can see that there is a strategy to silence the media using my idea is that we should work on that, civil society, the UN, and actually we should maybe use the expertise of maybe some consulting firm to make it clear that it's completely bogus. You know, this is completely bogus. This accusation, they're just used because I've read in some cases where the accusation they're absolutely completely crazy. The newspaper, to give you an example that I read, the newspaper received some crowdfunding fund. A person gave $10 to help the newspaper from the diaspora, and then the tax authorities say, no, this $10 has to be accounted like $10 every month for the year. It's just a one-time payment, but it's nonsense. But with this, you can attack the newspaper. You didn't pay, make a penalty, and etc., and you choke the media. It's just to give an example of the way very sneaky, powerful interest will use this kind of thing. So I think I had this idea, what you're mentioning, to work more on that, to have more concrete study on that, a concrete report from our side and from the society, I guess, in order that we get more aware of that, and we can and then adopt a strategy also to debunk this kind of attacks.
The special collection is growing.
But then, fortunately, the attacks on freedom of expression are also multi-pronged. That's the problem.
I might even ask, maybe if I can hone in, Barbara, for you. I know we've been talking about this process point and the question of how judges can identify these cases. Are there particular tactics that you think would help judges in understanding, to Mehdi's point, is this a real tax concern, or is this bogus sham meant to shut down the media?
Well, I guess it will depend which country, because if it's a country like Belarus, I don't think the best SLAPP protection is not going to help you, because the judges are just, extension of the state. And I actually haven't seen this kind of tactics from quote unquote democratic countries. So even I was looking at, because earlier we were talking about lawyers, Article 18, Article 17 of the European Convention. If you look at the abuse of rights under those provisions, majority of the cases come Azerbaijan, Russia, Ukraine previously, Turkey. So it's not really the countries where judges will be kind of accused of misuse, right? So if you talk about democratic countries, it's slightly different issue. And when you are talking about totalitarian countries or countries with no rule of law and no independent judiciary, those judges don't need the guidelines because they will disregard them. I don't know whether that answers your question.
Well, let me try again, which is, is there anything that could be put into a guideline that makes it harder for a judge to skate by? And by that, I mean, so for instance, I know you mentioned at the beginning in your remarks that there's not really a checklist. It's, variable by country. They do abusive right, abusive process. What if a judge had to fill out a checklist and had to fill it out? Are there any tactics where you can, or is it a matter of judicial engagement and more training, where maybe not at the extremes, but in other scenarios where a judge might be reluctant to apply guidelines or have some hesitation? Are there ways of pushing?
Yes, within admissibility criteria. Because I think, at least in the countries which I'm familiar with, the aim of the court is always like dismiss the case. It's to just like have as low number of cases as possible. So they look at admissibility criteria. So they look at whether this was filed to the right court, or whether this was filed on time, right? So whether this was within the statute of limitation, or whether the fee was paid, right? So if in the criteria, which then they need to look at, for the cases to proceed further, you can have this checklist. Right? I think for majority of the countries, you will have to have the form of legislation. You will have to have amendment of the admissibility criteria in the civil procedural code or other. But yeah, that's a possibility.
I would say there is also a difference between civil law system and common law.
Common law system, yes.
Because in the common law, you can have a decision by the Supreme Court that will establish the criteria. And that will give an idea for all the other courts, lower courts, that this criteria have been developed. But in civil law, the law is really much more.
I've got another question from the online audience, but I think it's a comment actually. Is there a way to allow someone to comment? No.
No. Only
so I think I would need it in writing for the colleague who had a comment or question relating to EU legislative processes. I will let them, if you can hear me, please go ahead and type in any question you have, and I would be happy to ask it. In the meantime, though, I just wanted to make sure we had another go around the room. Yes.
May I just ask, related to what Mehdi was saying about your interest in possibly working on a report on these bogus charges? Because the thing is that, as you'd mentioned, maybe it is happening, for example, in autocratic regimes, etc. But we may be seeing this, as we've seen with other tactics, right? Where it may appear in other areas. Because I work on emergency assistance for journalists at risk, media workers. And so we start to see these in the cases, we and our partners, right? So I think that type of report, or looking, at what you see now, we may be revisiting down the road and say, remember when, right? And now it's somewhere else. And also because what we're seeing is whether on tax, being accused of tax fraud, et cetera, misuse of FATF, being accused of money laundering, all of these things which appear as it has nothing to do with their journalism, and yet it does, right? And so that also may mean totally different type of lawyers. So the lawyers that we all go to for pro bono, for journalists at risk, et cetera, now you're talking about tax specialists, tax lawyers, who are, maybe a different level of expense. Those lawyers may or may not be interacting with freedom of expression, whether lawyers or others. So I think it is something that it's already there in the cases. Let's say we just have to wonder. So it would be something to start.
I mean, that's that's
digging.
what
Yeah.
we've been noticing.
Yeah.
And hence we say, okay, it seems to be, and it's a different type of attack. And we thought, okay, we have anecdotal evidence, but can we really have something more serious to really show that there is a systematic use in some context of this kind of a procedure against media related to tax. I think what you say is interesting, that it's a different type of lawyers. My idea was to involve maybe consulting firm, because they are accounting, because they are really specialists in that, and they can, because if we have a report that clearly with the survey and that really highlights some of these completely absurd cases, I think it really will show at which point it's absolutely not serious. It's just a way to silence thing.
Yeah, no, I was going to say the same thing also. And also these cases are in some ways even more pernicious because they don't rile up the community in the same way as an espionage charge or a journalist behind bars. And people think, well, there's, whatever, not as big a deal, but it still functions in the same way. It still has the same motive and the same outcome. So they're really I think they're very dangerous and very pernicious. So I think the report's a terrific idea.
So what we also have at Article 19, and also what we have been pushing for internationally for violence against journalists, is that whenever a journalist is killed or attacked, always assume that it's because of their exercising the right of freedom of expression. So that can be a similar kind of criteria, like when there is a case against a journalist, always assume that it's for their reporting activity. Later, it might prove it's not to be the case, but this is also not new. And also, if you look, there will be a lot of cases from Azerbaijan when somebody was planted drugs on, or and that's very easy, drugs, and maybe some journalists use drugs, and as other people, but and it took years at the European Court to actually free the journalist. And at the beginning, it was very difficult to understand for the community to see that this is really trump up charges. But there was another case in Azerbaijan when somebody was prosecuted for sex tape, and it was
which we now see another.
So always assume that when the journalist comes to you with something, assume it's for the exercising freedom of expression, and then if later proves not to be the case, then you can always dismiss it later.
And it's a good point about the example with Azerbaijan, because that then became so prolific in almost every case, or hooliganism and other things. Or, we all remember where it was when I would have cases on emergency assistance, I said, oh, let me guess, it's bad drugs again, because it was just so at certain points cut and paste, or hooliganism, or now all of the things that people have been talking about in all of these rooms during this week, so we're there with these new tactics.
And special rapporteurs on freedom of expression, they have a joint declaration on crimes against freedom of expression, and they have the same recommendation. Whenever journalist is attacked, always assume that it's for the exercise of the right to freedom of expression. Later it might be it's traffic accident, or fell down the stairs and killed accidentally, but always assume it's for their journalistic activities.
But also media, I think I think it's good to provide support from media on this issue, because it's interesting when you read, for example, a newspaper being attacked on this and exposing it, it's interesting to see on social media the type of remarks. You have a lot of people say, pay your tax and etc. But they will be much more difficult to say that when a journalist is being attacked because he said something, that displeased the government. But when there is this, you will have a lot of people the comments on social media are interesting in a way. And what else? What the other thing is that is also that maybe also media should be more aware that it's a potential attack against them, and they should be extra prepared. And I would say proactively make sure that there is no possibilities. Even you will have tax authorities that will find bogus things, but if you're extra prepared and you have your account audited by a renowned firm that might do it pro bono, who knows, that will be more difficult to attack, I would say. I remember the judge in France fighting corruption. And she said to her husband, who was a doctor, she said, every thing you will receive, every money as a doctor, everything you have to declare, everything you have to be 150% clean and abiding by the law, because they will come after me. And she knew that they will find anything to attack her because she was a very prominent judge anti-corruption. So in a way, a newspaper is under fire, is on the front line and can be attacked. And so there is, of course, the remedy, and I try to defend and etc. But I think to proactively be prepared that it will be might be a line of attack that will trigger less support internationally and nationally. I think it might be an interesting thing to have in mind at least.
And it could feed into smear campaigns, right? Like, oh, you're foreign funded, or you're this, if it's about tax, let's say, or something like that, or.
For sure. So we have about 2 minutes left. I'm going to take one of those minutes to virtually give the floor to someone virtual who had a comment, which I'm happy to share with the group. And then once I've done that, I'll give maybe each of you 30 seconds for any concluding comments, takeaways. But so this is a comment from a lawyer working for the Secretariat of the Legal Affairs Committee of the European Parliament, who wanted to clarify that the EU legislative process is not finalized. While the Council of Ministers is still to adopt the position on the proposal for a directive in June, the Parliament will also adopt their position with amendments in July. Only after that, real negotiations will begin, so the outcome is still to be seen, hopefully protective for the defenders of human rights defenders. As the proposal for directive is under civil law matters, it cannot contain defamation in criminal law, but this is a limitation of the EU treaty at the moment. The recommendation, which covers criminal law, is non-binding, and that creates a weakness there. And that is why most of the amendments of the European Parliament will try to take crucial elements from there to move them to the future binding directive. Hopefully, the negotiations at EU level will be finalized by the end of 2023, and if all goes well, to have the directive published in the first semester of 2024. So maybe that's additional detail. I'm happy to show you on my screen in case my reading it didn't do it full justice. So I will just say, before I give the floor to the panelists for concluding remarks, to a huge thank you both to the panelists and to the room for a really robust discussion. I think we've heard throughout the life cycle about the incredibly wide range of forms of legal harassment that can be faced, from the tax discussion we just had to the defamation to the civil claims, as well as then what can be done to stop it, from the great discussion we had about dissuasive effect and reparations for those who are using their official position to try to silence reporting, to the processes that, Barbara, you've talked a bit about that judges may employ, to the socialization with judges, maybe to get them aware of the way they can be instrumentalized, and then to those decisions that are featured in the report at the regional and international level on the standards. So that's it from me, but I want to give each of you a very quick 30 seconds for any last thoughts. Maybe we go again, Mehdi and then Barbara.
I mean, I think we have said a lot. So, but basically, it's to that all actors involved in this issue renew their efforts for campaign for decriminalization of defamation. That's and to have civil law which how to say, apply international standards on the three-part test to really have the necessity and proportionality in order that the civil law are not being used to silence journalists with this proceeding endless against media. I would say that also really, I would like just to remember. I mean, people know, but that this how to say, these attacks with SLAPP are a way to silence journalists. We are facing very powerful interests. People are very determined. It's not a joke. I will remember the case of Daphne Caruza Galizia, which we actually, in one of our training with prosecutor, we invited the chief officer of the investigation, who is also a prosecutor, to speak with the other prosecutor, and he explained the whole investigation, how they get to the top of the responsible, etc., of this heinous attack. She had over 45 how to say, judicial attacks against her when she was killed. So they tried to silence her with all these procedures and endless, and she was and it didn't work. And then they ended up killing her in her car. So we are in this realm of, this is one way of attacking and silencing, and that I think I just want to add that.
Thanks so much, Nidhi. Barbara, last word.
Yeah, I want to also mention something which we haven't addressed, and that's that when we talk about, I mean, protection against SLAPPs also requires quite considerable investment of finances. And when talking about that, there is a lot of focuses on pro bono. But I think journalists deserve, for victims of SLAPP, they deserve professional representation. It costs money, and you can't really always depend on the goodwill of a lawyer who might even not be even specialized in your field, because, you know, pro bono is like, you know, who wants to do this case? But unless you are really a specialist in the issues which you mentioned, taxation, even defamation, or even some of those like complicated investigations, you can't solve it through pro bono. So that comes with the, you know, funds, insurance, but also for the states to create funds from which this legal representation, professional representation is required, and not just to have this like pro bono obsession and thinking like, okay, like we will get a pro bono for a journalist and that will be it. You can actually end up with far worse result from someone who doesn't know what they are doing and just doing this pro bono.
If I can just add on this, the Global Media Defense Fund, which is run by UNESCO, is actually making regular calls. And this is actually this call offer grants for civil society organization to actually cover the cost to do strategic litigation, defense of journalists against SLAPP, etc. So there is this call that comes regularly, and that's one way of having some support to actually pay, as you say, the lawyers for them to do their job and to defend the media which are being attacked in that way.
Great. So with that, thank you, everybody. Thank you, Columbia.